So last week I posted about handling a request for further evidence in an O1B petition that I filed for one of my clients. So I'm happy to report that after I submitted the response to the RFE, 2 weeks later, USCIS approved my client's petition, and now he's officially in O1B status. So just to recap, the O1 visa is a visa for individuals who have extraordinary ability in what they do. And this could mean anything that's in the arts, to sciences, to business. Basically, any field of endeavor could theoretically count as an area where someone can show that they have extraordinary ability. So in my client's case, he was a painter, a fine arts painter who specialized in this particular method of painting that is rarely used today. It's called tempera. From doing my research preparing for this petition, it involves using eggs actually. So I think it's a technique that was used by a lot of the masters. I felt it was a strong petition after reviewing my client's credentials. Just to summarize some of his accomplishments, he is a recent graduate from his MFA program, but he already was being sought after by a lot of galleries in the United States and also abroad who wanted to exhibit his work. It's very rare for someone who just recently graduated from their master's in fine arts degree to already achieve this kind of level of recognition. He also won a competition and was featured in a volume about contemporary artists. He also had a few articles written about him in art journals and magazines and newspapers. Also, he had very strong testimonials from curators, professors, other artists. We filed the application with immigration. Not surprisingly, they came back with a request for evidence. Part of the process was kind of formulating a strategy to respond to the RFE. But the other substantial part of what lawyers do is kind of working and collaborating with our clients, right? Because the legal work aspect of it, coming up with arguments to rebut immigration's allegations, is only part of the job. The other part of your job as a lawyer is your relations with your clients. Do you have a good rapport with your clients who are coming to you because they're dealing with a very stressful problem, right? Immigration is super important, to anyone who is here in the United States who doesn't yet have a green card or U.S. citizenship. The process of navigating through immigration law is not easy at all. It's a very complicated area of law. It doesn't make sense a lot of the time. With my particular client, he was very, very anxious about his future. He came to the U.S. for school, bright career ahead of him, but the impediment was, would USCIS also agree that he was an artist of extraordinary ability? That's a lot of power and discretion for one agency to have. Especially your average USCIS officer is not necessarily going to be an expert on fine art, right? So that's another part of the job of the immigration lawyer, is to kind of educate and a lot of the time remind immigration, this is the law, these are the standards to qualify for an O1 visa. And I find myself having to do this a lot with USCIS, is reminding them what the law says and what it doesn't say. Because a lot of the time the RFE will just randomly make up law, right? That's one of the things that USCIS likes to do. So he was very nervous. And as an attorney, you have to be really careful. You can't ever really guarantee an outcome to a client because no single person has that kind of control over immigration. I can't demand that immigration approve my client's case. A lot of the difficult work was kind of coming up with a strong response to the RFE, but the other aspect of it too is also dealing with the emotional, not so tangible parts of working with clients, because we're in a service industry. Clients are understandably very nervous about the worst case scenario. And my client throughout the process would ask me periodically, what if this is denied? What are my options? Can I stay in the US? When do I have to leave? When am I officially, quote unquote, illegal or out of status? By the time that we filed his O1, he had already graduated. He had 1 year of OPT, or optional practical training, which is the work permit that you're entitled to after graduating from a bachelor's or master's or higher degree. So he had just run out of his work permit, right? Wasn't eligible for an extension because not a STEM major. So there was this huge question mark looming over him, that would have basically would affect his future, right? If he's not able to secure an O1 visa, that means he'd have to pretty much leave the United States, go back to his home country. A lot of foreign students come to the US to get a great education, but also to hopefully apply their degrees so that they can work in the United States. So it's a huge gamble, right? And especially given how difficult immigration law is and how low the percentage of getting selected in the H-1B lottery is, that says a lot about foreign students who are willing to come here, receive an education, pay the very high tuition, and then not have like really strong, viable options to remain in the United States and work in their fields. So the day that I got the notice that his O1 was approved, it's one of the favorite parts of the job. Is like finding that all the hard work that you put into it paid off, and that you get to share with your client the good news that you know um, we did it. We accomplished what he set out to do. He now can work as an artist for the full 3 years that we requested for the O1. He also just got officially notified by another gallery that they want to represent him. So they're going to be exhibiting his artwork, and any sales that come from it, they're going to be his agent. So doubly great news for my client in the same week, and I'm really happy that we were able to help him get his O1 approved.